Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing what is missing from all too many severance pay packages. Now, when you've been fired or otherwise terminated from your job, and your former employer leaves you with this termination and severance pay package and says you have very limited time within which to accept or decline that package, you need to understand what is not only contained in the package, but what is all too often missing from the package. Because what you'll find is you'll get this pay package and it'll be full of legalese and have a lot of things that it's attempting to supposedly cover. And it's going to make you think about it and say, is this adequately covered? Is this aspect adequately covered? But it's what's not stated directly in the package and what it in turn says indirectly, which is of very great consequence. Because one of the greatest aspects that's not covered in far too many pay packages with respect to correcting or to addressing inadequacies therein is earned pay, otherwise known as back pay. Money that you have earned over the course of your employment with that particular employee that has not necessarily been correctly calculated in accordance with the laws of the jurisdiction within which you are working. And now it's not being addressed as to whether or not they've made a review of it. All they're doing, and you'll see this particularly where you have a release accompanying your termination and severance pay package, and even containing the overall cover letter, is that you're accepting this package on the basis that no further money will be due to you from your former employer. And that might be all good and well if everything during the course of your employment was correctly calculated and paid for. The problem is, in far too many employment situations, especially those away from the locus of payroll education, payroll software development, there is a very high tendency to have payroll not structured in accordance with the laws governing the employment situation. And when the laws are inconsistently applied, and you're applying the laws from another jurisdiction, and we're not just talking about laws of a different province, we're often talking about laws of a different country. And I know this might sound shocking to a lot of people, but what we see is that is the reality. And because of the challenges, because of software and training of payroll staff, people don't recognize that. And there's another problem that's associated with this, is that payroll is done by payroll specialists, as they're called, and by payroll software that is often coming from out of country and is not being managed and overseen by lawyers who are trained and admitted to practice in the jurisdiction in which you are working. And because of that, you run into these very serious problems associated with payroll and underpayments during the course of one's employment. But it's not for the employer, they believe, or the employer's lawyers to go through and do an extensive review and to see if they've been mispaying over time. No, they just get formulaic, template, termination letters, push them out, standardized severance and termination pay packages, releases that are pushed out, and they say, look, you, the employee, if you have some issue, you deal with it. You bring it to our attention, and then you have your lawyers bring it to our attention. But until that time, we're just going to give you the standardized package, and we're going to give you the least amount of money that we think is appropriate, that we can get away with, and that's what you're going to get. And it's up to you as the employee who's now been terminated, and unfortunately does not have a job at this point in time, to deal with the situation. And if you just simply take a review of it. You'll look on the internet. And unfortunately, if you go to lawyers who are not attuned to the issues of payroll when it comes to individuals being fired and terminated from their jobs, you're going to find yourself probably accepting the situation or even being told by a lawyer that the situation's okay. And yes, in many circumstances, it might well be fine. But are you going to chance it? Because what we see, at least out here in the province of Alberta, but I've also seen elsewhere, if you're at the federal level working in Canada, there's also a problem there. There's problems elsewhere across Canada. But if you allow yourself to be drawn in and simply accept this, and not to have payroll extensively reviewed, you could be losing out on lots of money. And I'm not talking about a couple $1,000s. No. What we're talking about is tens of thousands of dollars, potentially in excess of $100,000 you could be forfeiting by not taking the time to review the full scope of your termination severance pay package as tied to the payroll situation. And this is very critical. Everything is tied together and everything needs to be reviewed together. Because there's actually cases that show that people have gone and challenged stuff, and we're talking not about, like I say, a few $1,000s, a few $100s. We're talking about sometimes $25,000 per year of employment that was unpaid or underpaid. And that reflects both with salaried employees and hourly employees. Because it's not as simple as you might think. It's not as simple as the payroll people think. And it's definitely not as simple as the employer thinks. Employers think you're getting paid way too much as it is. That's the reality that we're dealing with. But what's critical is that payroll is being operated on by non-lawyers. And lawyers rarely, if ever, get involved with payroll on the operational side as the business is going on and on. Yes, they deal with it when the person is terminated, but then if you even look at the letters, they're focused on the end payments, not the payments of money that was earned during the course of employment. And there's so many different aspects I could bring to your attention that shows you that there's a severe disconnect as between what the payroll people are doing and what the lawyers are doing and what the law is. Because everything is dictated by law, not just with respect to your termination pay and your severance pay, but also with respect to your earnings during the course of your employment, and as such will dictate whether you've been underpaid or simply been unpaid certain payments that are due to yourself for work that you have completed, and this is money that's earned and outstanding to yourself. But what do most people do? They simply don't put the time in, they don't engage with the right professionals, and they allow it to go past them because it's complicated. And even the lawyers oftentimes don't really go past it. It's shocking that so many lawyers fail to understand this stuff. And it's right there in black and white before them. And yet, even though it's there before them in black and white, they're trying to figure out some way to get around it, but it's too late. This is money that's been earned, often years before. The structure's in place, and it has to be dealt with. And as such, you need to be dealing with it. And you can't simply take stuff on face value, because on the face of it, these termination severance packages might look complete and complex and be paying you appropriate money. But once you really dig into it, then you start to realize that there is significant money that's possibly outstanding to yourself. We're not talking about every scenario, but far too many scenarios show us that money is outstanding. Money is due to employees who've been recently fired. And it's not simply the money from termination severance pay, but it's earned money from the course of their employment due to the fact that employers are not following the laws with respect to payroll of the jurisdiction in which the individuals are employed. And that's the critical thing. And because of the critical nature of it, that is why employees need to be retaining knowledgeable legal counsel who understand the laws in their jurisdiction. Because that is absolutely essential to overcoming what I would say are mistakes or deficiencies or pure interest of paying the least amount to employees when the law dictates something more. So if you've been fired, terminated, or otherwise losing your job, and even if you quit your job, and I know this sounds a bit crazy at times, you need to be looking at this diligently. You need to get the right lawyer who will work with you and approach it correctly. Because the fact of the matter is, from my perspective, I look at this, it takes me a couple minutes if I get the right paperwork in front of me, and what shows up? Underpayments, failure to pay. And within a few minutes, if you know what you're doing, you can discern a couple $1,000s a year, $10,000 a year over year of money that has been earned and is due to the employee. And that is a challenge you face. That is a challenge you have to immediately address, because if we're talking about money that you've rightfully earned, you've legally earned, you should be collecting upon that money. If you don't want to collect it, that's your own choice. But it's your money, you're entitled to it, and you need to deal with it appropriately. Thank you.